Thank you. Good morning, Brett. And again, my apologies for Dan Andrews keeping us out of Queensland. We're in a red, yeah, you guys are in a red zone for us. If I'd gone up today, I had 14 days in quarantine when I got back. So I think you understand. Now, I'm going to share a screen with you. Hopefully that's come through. If not, Mel has a copy there that she could upload. And I'll see if I can blow that up.
Can you make it bigger? Yeah.
I can give that a go.
Yeah.
Okay.
That's better. Yeah, we've got some old people in the audience. You know, eyesight's always a struggle for us. Cool. Thank you.
Okay. Now, this came out of some work that I was doing earlier in the year for a presentation on ethics at the tax bar. And it came about from some concerns that I had running matters or preparing for matters at the tribunal. And I'm not sure that people have thought through, and I was listening earlier to the material from the 570 people who'd had go through the tax clinic. No doubt some of those would have been looking at being referred to the tribunal or the small claims tribunal. And the concern that I set out to address is when you are dealing with the tax office at the tribunal, what assumptions do you take about the way the tax office will approach you? And I know people will say, oh, well, they're a model litigant. That solves it. Not quite. Now, if you look at the table that I've put up, you'll see that I've got there 3 columns, and to make it easier today to talk about the different cells, I've marked those cells A1, A2 and B1, B2, etc. And if we look down the left-hand column, this is the range of situations you can encounter. You could have an ATO employee with absolutely no legal qualifications. Could be someone who's not even gone to uni. You could have an ATO employee who's completed a law degree, but not ever been admitted to practice, therefore is not an officer of the court. Then you come down to, well, you could have an ATO employee, who has legal qualifications and who has signed a roll of either Supreme Court or the High Court or both. Then you could have, well, that's one scenario. That's where the ATO runs the matter without counsel at the tribunal. And that's most often what you would get at the small claims tax area, and what you get very often even at large matters at the tribunal. The next alternative is across in the right-hand column, B1, B2. There, the ATO will run the matter with external counsel. And as between counsel, you anticipate that counsel will all operate on the same ethic. And that's drummed into us when we go to the bar. And so, again, you can have situations B1, B2, B3, but this time you can actually get 2 different variations. One is where the AGS lawyer is doing the instructing to counsel. And then more likely in the debt collection area, you will pick up a private firm lawyer acting or instructing counsel. And sometimes you'll get a private firm lawyer actually running a debt collection matter in the federal court. Now, what does that do to the way you approach the matter? If your default position is that the ATO is a model litigant and will honour the model litigant obligation, be very careful. The ATO does not systematically ensure that each person acting in that position is even aware of the model litigant obligation or what it involves. And that has implications down the line. In particular, in the area that I got most interested in, it was with where as a barrister you're instructed by a person who's not a lawyer. And what that does and the conflicts that can create for the barrister involved. So I went through, if you looked at it on a simple method as counsel, what would you prefer if you were working for the ATO? And cell B4 to me is the optimal position. You have an AGS lawyer who is instructing you. Far superior position than where you have an ATO employee who has no personal overriding duty to the tribunal. So if you think through that, a lawyer who's signed the court roll has an overriding duty to the tribunal that goes beyond their obligation to their client. And I'm not sure if people had, and because I'm not seeing any facial expressions, I'm not getting any feedback at all from the audience. So please yell out if something you want to ask. More than happy to take questions on the fly here. So that paper was prepared and delivered and generated some really good discussion in the room. There were quite a few senior lawyers in the room. And really, okay, well, what happens? What happens if the person instructing the barrister doesn't have an obligation to the court? Well, the commissioner does, but if the commissioner's employee has no idea, it's not likely that that obligation would be honoured. And where does that leave you if you're acting for the commissioner? But more importantly, where most of us will be acting is where does it leave you if you've made an assumption that something will go by the book and it hasn't gone by the book? Little did I expect that in such a short period of time, that submission that I made available to you to allow you to focus your mind on the difficulties, I didn't even anticipate that that would arise, and it's been desensitised for obvious reasons. It relies on the names of cyclists in the Tour de France, but that situation is really troublesome. And I'm not working for the commissioner in that matter. It's a matter where the applicable cell is B4, the one that I identified as the optimum position. Quite simply, in that matter, an expert witness was asked a question: have you had, a supposedly independent expert witness, have you had any meetings with the commissioner? And the answer was no, not in relation to this matter. And the follow-up question was, have you had any meetings with any employees of the commissioner? And this was chasing down the extent of the independence of the expert witness and whether or not that expert witness may have become an advocate for the commissioner. And again, the answer was no, not in relation to this matter. Evidence that emerged 2 days later, when the witness was asked to produce the file notes that she agreed that she had,